Welcome back to the channel. So as a barrister, many of you know that I'm interested in reporting on live cases and giving legal commentary on those cases, as is the case with Alex Belfield and his case which has just commenced in Nottingham Crown Court this week. And I've looked at one of the videos and there are several comments to that video of Alex Belfield where people are concerned about his reporting of the case, indeed reporting of his own case, and potentially that might extend to concern over the note-taking and so on. So I thought I would do a brief explainer video to explain why this is actually okay, spoiler alert. But there are certain cases where it might be restricted, but as I understand it, there are no reporting restrictions in this case. But there are certain rules to follow, so allow me to just briefly explain one or two things. Now, indeed, note-taking by even members of the public is normally permitted, although you have to make an application first, but I'm going to come back to that in a moment. So there was one such case which actually went for judicial review, whereby the claim for judicial review, and it's this claim here, the claim was for judicial review concerning the circumstances in which it would be appropriate for the Crown Court judge to order that members of the public may not take notes of a hearing, otherwise being held in public. In this case, the judge directed that no member of the public could make notes of the proceedings without the judge's permission, and twice ruled that the claimant could not make notes. So, a long story short in this judgment, the judge in this case ruled that it was correct in the submission that note-taking in question would not interfere with or pose any threat to the proper administration of justice. And so just to briefly pause there for a moment, this is the underlying and fundamental principle, whether any such note-taking or any behaviour at all would interfere with the proper administration of justice, because to do otherwise would be contempt of court. And as a broad explanation for this, the reporting of any live proceedings or any publication about live proceedings or note-taking and these kind of things will amount to contempt of court if it tends to interfere with the course of justice. This is provided within the Contempt of Court Act of 1981, and it's a strict liability rule under Section 1, which means that any conduct will be treated as contempt of court if it tends to interfere with the course of justice in particular proceedings, regardless of the intent to do so. And under Section 2, this applies to any speech, writing, program, communications in whatever form, which is addressed to the public at large, or for any section of the public. However, there is a defence of innocent publication and distribution, which is when they don't know about proceedings or that it didn't contain such material and so on. But the important section in this case is Section 4, which is contemporary reports of proceedings. So again, subject to this section, a person is not guilty of contempt of court under the strict liability rule in respect of fair and accurate report of legal proceedings held in public, published contemporaneously, meaning at or around about the same time, and in good faith. So if somebody is publishing live or near live to real time what's happening in court, but they're doing it in good faith, they're doing it fairly and accurately, then it's not contempt of court to do so. And also in any such proceedings where it appears necessary for avoiding the substantial risk of prejudice to the administration of justice. But also in such proceedings, the court may make an order restricting such contemporaneous reports under 4.2, which is in any such proceedings the court may, where it appears necessary for avoiding a substantial risk of prejudice to the administration of justice in those proceedings or any other proceedings pending or imminent, an order that the publication of any report or part of it may be postponed for such a period as the court thinks necessary for that purpose. So think of an example where there might be a substantial risk to an individual, be it because of their age, be it because of where they work. The court might say, well, until the resolution of this case, nobody can report on it. And that's where the court might make an order under this section. Now, there's been lots of talk about whether people can take notes in court, and some people have been caught taking photographs and audio recordings in court. Now, make no mistake, this is definitely contempt of court in the latter, i.e. photographs and audio recordings must not be made. Now, this is a guidance document rather than statute, but it does refer accurately to what is permitted and not permitted. So it is widely known that under Section 41 of the Criminal Justice Act 1925, the taking of photographs is strictly prohibited. And under Section 9 of the Contempt of Court Act 1981, the use of sound recording equipment in court, unless permission from the judge has been obtained. But that brings us back onto the subject of note-taking and live reporting, i.e. live tweeting, or as it's known, live text-based communications. This guidance deals with that also. It describes live text-based communications including mobile social media such as Twitter, internet-enabled laptops, and so on. And broadly speaking, this deals with it under general principles. It provides that a fundamental aspect of proper administration of justice is a principle of open justice, so that fair and accurate reporting of court proceedings forms part of that principle. However, it is subject to the well-known statutory exceptions such as photographs and sound recordings, i.e., and for the avoidance of doubt, you must not ever take photographs or make sound recordings in court, unless in the case of the latter you have express permission of the judge to do so. And again, just to be absolutely clear, in the case of photography in court, there is no judicial discretion to suspend or dispense with this. In other words, even the judge cannot give you permission to take photographs in court. It's simply not allowed. However, unlike note-taking, when we come to the use of live text-based communications, in other words, your phone, your laptop, or anything else that's connected to the internet, this obviously will go beyond the general rule that mobile phones are to be turned off in court. Although, having said that, there is no statutory prohibition on the use of live text-based communications in open court. However, the guidance does provide that where a member of the public who is in court wishes to use live text-based communications during court proceedings, an application for permission to activate and use in silent mode the mobile phone or any other device solely to make live communications of the proceedings will need to be made. So, in other words, you must make an application to the judge if you wanted to do this as a member of the public. So just to make that clear, you can't just turn up and start doing that without permission of the judge. Practically speaking, you would do this through the court staff rather than directly to the judge. This guidance then goes on to expand that it is presumed that a representative of the media or a legal commentator, perhaps such as myself as a barrister who commentates on legal proceedings, from court does not pose a danger of interference to the proper administration of justice in the individual case. And it goes on to say this is because the most obvious purpose for permitting the use is to enable the media to produce accurate and fair reports of the proceedings. As such, a representative of the media or a legal commentator who wishes to use these may do so without making an application. So as in the case here, the judge has already said that Alex Belfield is a journalist, and so, albeit on his own behalf, which is unusual because it is his own case, but so long as he is doing it within the bounds of this guidance and the statutory provisions in the Contempt of Court Act, i.e. that he's making live text-based communications at or around the time of the trial, which is most likely going to be afterwards because he's not likely to be doing it in court. But as long as it is providing a fair and accurate report of the proceedings, fair and accurate obviously being without his opinion, without trying to sway the evidence, he's just doing it with a fair and accurate report of those proceedings, there is no prohibition for him to do so, and he would most likely not have had to make an application to the court. Whereas you as a member of the public, if you wanted to go into court and use a laptop or a phone to tweet about the case whilst you're doing it, you could make an application to the judge through the court staff to permit you to do that. And so long as the judge is happy for you to do that, then the judge can, of course, give you permission. So as before, I thought this was an interesting legal angle, but just to reiterate, you must not ever take photographs inside a court building at any place within the court building. That is contempt of court, and even the judge doesn't have the discretion to give you permission to do that. Sound recordings are an equal no-no unless the judge has given you permission. But take it from me, the judge is not going to give you permission to take sound recordings of the proceedings. So unless it's absolutely necessary and you are from one of the large news corporations and you get permission from the judge, again, you cannot do that. As for note-taking, if it's simply note-taking on paper and things like that, that's generally taken to be okay. But if you want to use any live communications, again, as I said, unless you're from the media, you're a reporter or legal commentator such as myself, then you'll need permission from the judge. So, for example, if I were to go into court and start doing this, I may even get questioned myself, obviously, if I'm not in a wig and gown. But if I'm going in as a member of the public, albeit as a barrister, I would come under that exception of being a legal commentator because, obviously, I'm a barrister. So I thought you'd find that interesting. Please do like the video and subscribe if you want me to make more comments as we go through this case. Of course, I'm not going to be making any commentary that could interfere with the administration of justice and sway any witnesses, testimony, or jurors or anything like that. Whilst as a barrister I am permitted to give my opinion on cases, I am going to limit to fair and accurate reporting as we go through. So with that in mind, I thank you for your time, I thank you for watching, please do subscribe, and I'll see you next time.